Hello, Rob. James again. The first video was an awful lot of trouble, meaning that I do come on, and by the way, my Facebook site's been dormant. It was deactivated, and I've only activated it to come back to you. And this YouTube account is only getting live videos put on it to help you. And I'm having difficulty. So let's try and race through this. Okay, where the video had got to the last time, I believe, was I was explaining about the acts and statutes that were incorporated into the Criminal Procedure Scotland Act and the Scotland Act in 2013. Now, I've explained about asking for declarator. So you've got the position there where you can ask for declarator under Section 34 of the Scotland Act to the Advocate General, where you'll explain everything that's happened and ask them if it's legal. Is it lawful? Right? Two different questions. The compatibility issue with the European questions anent the Scottish Minister's legislative force as to whether they have got the power and legislative force to bring forth such a statute and act that sees you before the court and allows everybody to act accordingly the way they've been acting. Is that legal or lawful? Right? The other European questions that need to be asked, Rob, right? To act to a journal dealing with this. It doesn't go that far to explain about European questions, unfortunately. The Acta Journal will explain that this is an appeal from an inferior court to a superior court. Now, under sections 288 ZB1 to ZB2, 3, 4, 5, 6, 7, the Criminal Procedure Scotland Act 1995, as amended on the 22nd of April 2013. Under those acts, what you can do is raise what's called a compatibility issue. Public bodies, the local authority, councils, and the court service. The Sheriff Court is a public body that's authorised and operated by the local authority, which is a conflict of interest, I may add. However, what you're asking there under these sections as to whether these local bodies are acting ultra vires. So read here to apply to you. If you read 2.5, where you are asking European questions. Now, you've already asked European questions with regard to the Crown Prosecutor Fiscal Service and also in regard to the Scottish Ministers, who are a public body. The court service, the building itself, the impartial tribunal that has been set up to hear this honourably and with impartiality and with no influence from outside. You are now asking under sections 288 AA5, you're asking European questions as to whether the Sheriff Court Service is acted in accordance with them and the European law and international law. And we all know that they haven't. Now, Lord Gill, back in 2013, done 3 tours of Scotland, explaining the transference from what was then at the time a devolution minute. To let everybody understand, a devolution minute is where any of the Scottish ministers, any of the courts, everybody apart from the police basically, because the police aren't covered with the Scotland Act, everybody involved as local bodies, local authorities, social workers, everybody, the court service, everybody employed in the court service. Lord Gill done a talk on all this, and he was really angry that he had to do 3, and he really let his unhappiness be heard. I was fortunate to attend a meeting that getting held in court on a Friday. It wasn't to any advantage to my understanding to what I'd already understood. But for you here today, under sections 288 AA5, if you want to ask European questions, then accept it from me that the Sheriff and the Sheriff Court at a domestic level, which is basically the court at the first instance, has no authority to do anything else. Nothing. They can't continue with the case until European questions have been asked and European directives have been sent down through the European Court's Community Justice, from them to the Scottish High Court, and then on the Scottish Sheriff Court, telling them exactly what they must do in these circumstances. And the reason that the court can't continue with any other ultra vires procedure is because there's no sheriff in the planet can come up with a just and sound decision without the European questions being asked, which is something the sheriff has not got the remit to discern or a judge. They can't do it. And that's why it's European questions you're asking. So you do that on a forum, it's a 40.9 forum. You'll delete the relevant parts that don't apply to you on that forum. And the sections that you want to be utilising on that forum is the accordance of sections 57.2 of the Scotland Act 1998, and you need to write as amended on the 22nd of April 2013. I would also advise you go and find the transitional consequential provisions order that was written about that. Also type into the internet compatibility talk at the bar. That'll come up with the Bar Association in Glasgow, which I was a member of up until no long ago, where I started a massive debate in 2013 dealing with independence and the compatibility issue, and I was really miffed at just how much these people didn't realise. And they were even more miffed to figure out I was just a bloke in the street, right? But if you want to stop your case dead in its tracks, you must raise a compatibility issue, Rob. It's the only way you can do it. Now, I can't get to you, so you would need to come to me. But if you can come to me and we can sit down and spend maybe 6-7 hours talking, writing, we'll produce a document that'll be one of the best ever to be produced in Scotland, dealing with everything that surrounds you and everything that surrounds everybody else. You've really got to understand the principles of the Procurator Fiscal Service and the Police Service of Scotland and the Sheriff Court Service. It has been three different, complete different organisations. And where the Crown Procurator Fiscal Service, the Procurator Fiscal, is the master of the instance, and he has got a legal right to bring legal challenges before the court. What you're asking is whether he's complied by the Procurator the Procurator Fiscal's Code of Conduct and the Book of Regulation, and a load of other stuff that's been brought out by the Lord Advocate at the time, Frank Mulholland, and all sorts of aspects dealing with disclosure, what the Procurator Fiscal must discern a judge before he brings a legal challenge to the court. Then you've got to look at the situation because of the legal challenge in which he's procured before the court on the evidence that he's got. And there's things we need to talk about on this, Rob, because there was acts in 2012 and 2013 that then identified the police and their now partners being able to share information and act accordingly in meetings between the Police Service of Scotland, social workers, doctors, the council. Every local authority has got a Police Service of Scotland member working in there. And that's how they get round all this. Now, what's an interesting point is when they were being passed, or before they were ratified, there was letters and loads of reports written by sheriffs, social workers, local authorities, all different types of departments, to the Scottish ministers, raising their apprehensions about these acts and statutes allowing the Police Service of Scotland to share information like this. And one of the things that Lord Gill, along with 7 other High Court judges, came out with, right, and I've got the report, is although in theory it's a great idea, they said in theory, but the situation will arise, and it will arise immediately. that when a local authority, a public body, being the council, social work departments, and every other department involved with the local authority, right, starts to act as if with the office of constable. Okay? So the reports that the Procurator Fiscal has received, acting on behalf of the Lord Advocate, is reports where people without the office of constable, who have got no authority to act as if with the office of constable, have been doing so. They have been doing so, and they have manifest the reports and claims against you and against your family that then sees a prima facie detailed case before the Crown and Procurator Fiscal Service, the Procurator Fiscal. So the information that he sits with before the case is even challenged in a court has been written ultra vires, because it's been written by people who have not got the office of constable, cannot act as if with the office of constable, and not only have they taken decisions and merited decisions that is subjected to you and your family to inhuman and degrading treatment, which is persecution and torture by the state. And by the way, torture is failure to get effective remedy, redress and accountability within a 3-year period at a domestic level, right? The persecution is there because the whole 3 services are now involved in this cahootsness and try to bring a legal challenge against you that isn't illegal nor lawful. Other aspects that you need to be looking at as well is every single meeting that has been taking place between the police, the local authority, social workers, every single one of those meetings where decisions have been taken to act against you. Under Article 6, Paragraph 1, the right to an impartial tribunal. Article 6, Paragraph 3, the equality of arms, tells you that they must write to you and invite you along to these meetings. And I know that that has never happened. So for every meeting that's took place, that's generated a report that now the Crown and Procurator Fiscal Service are dependent on, has been taken ultra vires and illegally. So there's where your European question rests there. Has the Crown and Procurator Fiscal got the legal authority to bring a prima facie detailed case before a court when it's acting on evidence that has been claimed ultra vires in contraventions of Section 57.2 of the Scotland Act 1998 as amended the 22nd April 2013? Has it complied with Article 6, Paragraph 1, where you were brought along to that impartial tribunal and you were actually involved and effectively a force there? No, they've never done that. And now that it's before the Sheriff Court Service, can they wholly rely on any of this information in light of the illegal performance of the local authority and the procurement of the reports that's been manifest whilst acting with the Office of Constable when they've not got the Office of Constable? So the reports before, every single report, it doesn't matter who's written the report, by who, when, how it was done, how credible it would be on intelligence, right? Every single one of these reports must be scuppered, and you do that by asking the European questions under sections 288 AA5 of the Criminal Procedure Scotland Act 1995 as amended on the 22nd April 2013. So then we move to the court. The Sheriff is governed by the Promise of the Oaths Act 1868. There's no point in going into court and saying, oh, you hearing your oath and I'm calling you in your oath and the oath this, that and the next thing. A waste of time. Your first statement regarding the oath is, it's quite obvious that you have abandoned your oath here today. You have scuppered the legal challenge being brought by the Procurator Fiscal. And as this is a recognised situation, I now must ask you to recuse yourself. And you motion that verbally before the bar. When they refuse to recuse themselves, You're going to be standing with the paperwork on appeal against refusal to recuse. Type that into the internet and you'll get the proper forms for the Scottish Government website. Fill in the forms, Rob. You must. When she refuses or he refuses to recuse themselves, you put in that appeal at once. And again, what you would mention in the appeal for recusal forum document, which is basically a writ that you write, is all the things that's wrong with the services, all the things that I've mentioned, and much more that we will discuss if you can quite clearly see that you need to be helping me and I need to be helping you. As opposed to running with this fucking diatribe that's been set by your pals in the Scottish Sovereigns and Fresh Start. The biggest mistake you made was going to the Dunblane meeting and sitting next to David Scott whilst Nala was asking questions in the audience. Come on, Rob. Are you for real? Because if you are for real, you'll take my help now. So there you have a powerful document under Section 288AA5 of the Criminal Procedure Scotland Act, as amended, like I say, on the 22nd of April 2013. You're questioning the validity of the sheriff's oath, the Bangalore principles, the bench handbook when dealing with laypersons. The fact that the court is expecting you to act like a lawyer and they're making their decisions on the basis that you're a member of the Law Society and you haven't applied yourself appropriately or accordingly to the rules and the regulations that's set up just to govern that society. No, Rob, you're a layperson before the court, whether you want to call yourself a common law advocate or whatever the fuck you want to call yourself. What you are before the court is a layperson. You're unrepresented by any member of the Law Society, so therefore the rules and regulations and the pro formas and everything else does not apply to you. But if you read McPhail Sheriff Court Practice, Renton Brown's Criminal Procedure, 4th edition up, you don't need to read it all. Just get McPhail Sheriff Court Practice. After 2013, because there are a lot of amendments. And if you look at that Sheriff Court Practice, to help you what you're looking for, is it will tell you that the court understands, and it is the position of the court, that when a lay person comes before the court and motions before the bar what they've got to say, the sheriff must at once inform the clerk of court to take that information, put it on the proper performer, and make it legitimate before the court. If he or she is not prepared to do that, then what they must do is give you judicial instruction. No advice or anything else, judicial instruction on how you can make that valid before the court. And they can't continue with any other procedure until that's been done. I'd be quite happy to come through to the Court of Session with you and to speak to the clerk, who is very helpful. She'll tell you all the same things that I've told you, and she'll agree with everything that I've said, and she'll insist that you must do these things. Now, for those of you that say, well, you've sort of contradicted yourself there because the rules and the regulations of the Law Society doesn't apply to Rob because he's a layperson, which is absolutely right. But for the competence of any document before the court, these things are requirements that must be done. However, also in McPhail Sheriff Court Practice, there is a position, Rob, right, where if you turned up with lipstick and toilet paper and wrote your claim in Swahili and gave that to the court, the sheriff must, ascertain and adjudge it, instruct our clerk to put that on the compatibility issue form, the 40.9, and accordingly, particulars are detailed. There's also another angle for the sheriff that's been ignored, and that is to treat whatever you say and to treat whatever document you tender as having the legislative force of a compatibility issue, because you can't be expected to do it competently as a solicitor would. So she can't use that sort of a bar. She can't use that line, to accept or no accept. Supposing you've written it in bog paper, with lipstick, in Swahili, she must make that competent before the court, and the fact that she doesn't raises what you should be doing as a plea in bar. A plea in bar is quite simple. You just sit right until your fingers are broken, explaining everything. And for those reasons, you're now raising a plea in bar is how you would end it. Now, Rob, there's an awful lot of things you need to be doing, and you need to be looking at before, was it the 20th of March you're back up? But I am angry with you for the way you've treated me. I'm one of the few people that could stand up and get something done. And to understand that, Rob, then it's to understand why they've absolutely decimated me, using people like yourself. So it's a bit of a conflict of interest and a contradiction that you've got gone there about all the people coming together and all the rest of it. Stand up for this. Rob, I've been appearing in court since I was 17. Bus companies, taxi service, anything. So I've got main problems I'm trying to work my way through. And 3 years for the last time. And it says what happened to you have happened. The plan to your family's children for what you are doing in the courts is well underway. And you must stop it. And you're not going to the march and turning up with, because the sheriff hear or see you, because you haven't claimed the jurisdiction of the court to be heard. And the only way you're going to ever do that is by way of compatibility issue. And I advise again that you do it at once. Now, Rob, this video has went on for 24 minutes. I'm actually quite to let you know what you must be doing immediately at once, not just for you, but if you love your sister, if you love them, you'll listen. If you love them, forget about the common law aspect of things. No. If you want to deal with them on their level, and the only level they can hear and see you, then that's what you've got to do. You've got to raise a compatibility issue under sections 28AA5. Any other section, none. What else you'll also do is raise compatibility issues that can be heard at a domestic level on the local authority dealing with social workers and reports and everything that they've made in the past. Now, if you start to make headway with that, you're going to win for all the family courts. It's just, for the last 3 years, I've watched people suffer because folk like are just not listening. Everything you've tried, Rob, everything you've done hasn't worked. It's not going to work. I've been at it for 30 years, mate. But we do have now a situation in this country where the Scottish ministers are ultimately responsible for the court service, the police service, and the Crown and Procurator Fiscal Service, and they're all acting ultra vires, acting in concert criminally with each. You're going to get the Scottish ministers or anybody to pay attention to this is when the European Courts of Community Justice receives an action from you for persecution and torture by the state. The European Court and say to you, until you've affected at a domestic level, we can hear the case. Well, that's changed because you have cases gone all the way through, and they'll start to the fact that effective remedy, redress, accountability you need to make. With you anywhere. absolutely anywhere. Try to get because it's ineffective. Completely in a dark room with a living matter, Rob, and try and accept something, Rob. A real, live, living pedophile not do what I am. And what you've got to understand, we move into an area and a whole load of abuse starting to come towards us. The reason we come to Bodom to do it was because it resettles sex offenders. The place is one of the sickest places in the country I've ever put myself through the endurance to collect the evidence that I'm collecting. Because see, at any time at all, Rob, is anybody caught in a pedophile because they can't. They just can't do it. The evidence that I've collected up in the last year up in the northeast of Scotland is new in the hands of the Scottish ministers. They're trying to deny responsibility, so I'm in the same position. We've gone straight for a European hearing at the European Courts of Community Justice and Persecution and Torture by the State, and I'm asking for immediate removal for the country for the protections. Rob, you and I must work together. You don't need anyone else. And Janine Rennie, the open secret, are you waking up yet? I'll leave it at that. Thanks for listening. And please believe me, you need to get back in touch. You need to get back in touch today, Rob.